All right, good morning. This is Judge Krier. I'm just asking that you guys mute yourselves until I call your case. It's a couple minutes before 8:30, but I'll start calling the docket and we'll see who's here. Has anybody settled anything they want to tell me about? I'm assuming you haven't, so we've had a number of things fall off the docket. Okay, no. Kathy, anything you need to tell me about before we begin?
No, I'm good, thanks.
All right. All right, so first case that remains on the docket is Benson versus Privileged Underwriters, 20 CA 1004. Who's here for the plaintiff?
Xavier Rojas from Guy Foods of Tyler, Your Honor. Good morning.
Good morning. Anybody here for defendant?
Yes, Your Honor. Good morning. Patrick Carlton on behalf of defendant.
Okay, so this is plaintiff's motion for relief of court order enlargement of time for disclosures and exhibits, etc. Also, I wasn't really sure whether you wanted an extension on the trial date. So plaintiff, Mr. Rojas, why don't you tell me what you want here?
Yeah, Your Honor. Right now, we feel confident that we could, if we have some trial deadlines extended, we may be able to comply. I know we've got an arbitration coming up here in very short order. It's a hybrid mediation arbitration. We are hopeful that we're going to settle then, but in an abundance of caution, I would still like to perform some, take some additional depositions. And I know we're a bit farther outside of those deadlines, and I don't want to run afoul of any.
When's your arbitration?
I'm sorry, what was that?
When is your arbitration?
The arbitration. Yes.
Go ahead, somebody.
Yeah.
I'm sorry, when is your arbitration? You gave me a date. I didn't hear it.
Your Honor, it's August 8th.
Okay. Well, it's just barely in fact, yeah, that's outside of my deadlines. You're already violating my orders.
It wasn't for a lack of trying. We tried with Mr. Weinstein, then he went on sabbatical, then we were trying for Mr. Teuber, and then he had open heart surgery in the beginning of the year, and it's kind of been a comedy of errors.
Okay, so when do you want to have your trial? Set for the trial period right now, beginning September 13th, pre-trial is August 2nd.
How's October looking?
Well, I have a tsunami of cases. So I have no idea what's going to happen. I think our courthouse is going to be completely open the end of June. So, we're going to be trying cases for the next 6 months. So I can't tell you. There's a lot of people.
I would prefer, if I may, I would prefer to push back trial till after the first of the year, because if we don't resolve at the mediation arbitration, then we'll get, because we're conducting, I would say, key discovery right now to prepare for the arbitration and mediation. And if we don't, we'll have some mop-up stuff to do and some additional issues to do discovery on. So I think that October would be a little aggressive. And I don't want to have to come back and ask you again for more time.
Okay, well, you're a 2020 case, so January 2022 is not completely out of the realm of possibility. So you want to do January of 2022? Is that what you want?
I'm fine with that, Your Honor.
I'm amenable to that.
Okay, so that docket, all my trial dockets are available online on the 20th Circuit webpage under my webpage. That trial date runs from January 12th through February 11th. Pre-trial is December 13th, 2021. We'll send out a new trial order, but I'm going to need a new case plan from you guys, because you're going to, just doesn't have to be a full-on case plan, but whatever the deadlines are that you guys need to adjust, just get them down in writing and send us a new case plan.
Will do, Your Honor.
Okay. And just know I have a 28-day jury trial that month. I don't know whether it's going to go or not, but we'll see. Hopefully you'll get it settled before then.
I hope so. We're optimistic.
Yeah.
All right. And you're still set for 4 to 5 days. Is that correct?
I think, 4 to 5 days should do it.
All right, so your motion's granted. If you'll send me an order to that effect, counsel, Mr. Rojas.
Yes, Your Honor.
All right, and then a new case plan by the end of next week. Is that all right?
Yes, Your Honor.
That'll work, Your Honor.
Thanks, guys.
Okay, thank you, Your Honor. Thank you, Mr. Ross.
All right, next case is Abruzzo versus Edison Insurance, 20 CA 2405. Who's here for the plaintiff? Anybody? Okay, how about defendant?
Good morning, Your Honor. Donald Levine on behalf of the defendant.
Okay, this is your motion for contempt and for sanctions So this is not looking promising, is it? Go ahead.
No, Your Honor. The truth is we've had a very difficult time sort of tracking down counsel on this. It started with the Cohen law firm, and then the filings kind of get confusing from there. It was filed by an attorney, Bayo Blackwell. Then there was a new notice of appearance filed by an attorney within the Cohen law firm. Then a change of address for Bayo Blackwell. It appeared as if he went out on his own and started his own law firm and was taking the case with him, which he actually indicated to me in an email. And then Cohen filed a charging lien, and that was in March of 2021. All of that happened. And since then, we've been unable to get any type of response from Mr. Blackwell. We've tried sending certified letters to the address he has on the Florida Bar website. I've called the cell phone number he gave me, which goes straight to voicemail. I mean, I hope everything's okay, but the truth is my client is here sort of needlessly spending money. There's a trial order now that's been issued, and I'm coming to the court asking for some guidance here. My request to the court would be that the case be dismissed, and when Mr. Blackwell sort of emerges, he can refile and we can take it from there. But for now, I don't know what else to do. I can't,
Okay.
excuse me, I can't get a definite date or discovery.
Here's what we're going to do. First of all, I am going to find him in contempt. I'm going to find his client and the attorney in contempt. I'm going to assess 57,105 fees against the plaintiff and the attorney. And then I'm going to set a date by which he must comply with my March 9th order. And if he does not, then you can file a motion to strike his pleadings and we'll dismiss the case. And you need to put all of that in an order so that he's clear on what the consequences are, and send it to every address, email, and otherwise that you have. And I don't know whether you have an address for the Abruzos, but
Yeah.
when you send me the order, if you would include, I'm not asking you to send that to them, but I will send that to them if you put the address on the order.
Will do, Your Honor. And 57,105, you're awarding sanctions. Do you want to include an amount or just leave it at that?
I'll reserve on the amount. You'll have to give me an affidavit or something.
Okay. And you said in a particular amount of time. How much time do you want to give plaintiffs?
10 days.
10 days?
Yep.
And then at that point, after the expiration of the 10 days, we'll file a motion to strike and to dismiss.
You got it.
Thank you, Your Honor.
All right. Thank you, counsel. All right. Next case is Francis versus Strayer, 20 CA 27. Who's here for the plaintiff?
Ed Larson on behalf of the plaintiff, Your Honor.
All right. Who's here for defendant?
It pleases the court, Irwin, Gilbert, Conrad, and Shear on behalf of the defendants.
All right. I've got a motion to strike exceptions from the plaintiff.
Yes, Your Honor. Prior to Mr. Gilbert's involvement in this case, prior counsel.
Am I hearing the exceptions today?
No, ma'am. It's just my motion to strike the exceptions is abandoned. Prior counsel had filed these exceptions, but never set it for a hearing.
Well,
And
that's because you guys are required to send those exceptions to me so that I set them by order and require you to file a transcript. Amazingly enough, I don't review all the 1,500 cases every day to see what you guys have filed. So if you have to take, that's what we do. So yes, you're right. It seems like it's abandoned, but go ahead.
well, and the bottom line is that basically prior defense counsel, not Mr. Gilbert or his firm, prior defense counsel never did anything. They filed the exceptions and they just let them sit. So, to get the case in posture for upcoming proceedings, I basically made a motion to strike as abandoned. It's been a year.
All right. I did take a look at a transcript that somebody forwarded to me, though didn't file in the court file. Mr. Gilbert?
Well, first, Your Honor, when we come in for another law firm, we get the cases, we find it. It's unclear to me why the plaintiff didn't file the exceptions or notify the court. I'm unaware that it's a unilateral obligation. But I think the larger point here is Rule 1.350 specifically authorizes the production of documents in the ordinary business manner that they're kept. And looking at the requested documents, And if
So
you're
let me just stop you here. I'm happy to hear the exceptions right this minute if you guys are both in agreement to that. Mr.
I am.
Gilbert? Okay, Mr. Larson?
No, ma'am.
Okay, well, so then I got to set another hearing for this.
Well, I mean, basically, I'm not aware of the transcript. I haven't read the transcript, and I don't know if Mr. Gilbert has, but basically,
Well, I just got it at 8:15, and I've read the transcript, so I don't know why you guys haven't read the transcript.
well, Your Honor, all right. So, I mean, we're gonna have if they want their exceptions heard, then they're gonna have to set another hearing for it, because bottom line is basically the magistrate has issued a report and recommended order. They filed exceptions. Nothing has been done on those exceptions for nearly a year. So if they want to set them, fine.
Well, and it's going to take now more time because you're not going to let me rule in those exceptions, Mr. Larson. So, okay. I'll continue this hearing on the motion to strike till we have an exceptions hearing. Since you've already filed a transcript, which is usually the purpose of me issuing an order setting the exceptions proceeding. Mr. Gilbert, since these exceptions were filed on behalf of your client,
Yes,
I
ma'am.
believe, you get to set the hearing. I don't need that much time. It's an appellate proceeding. So, at most you need 30 minutes.
Oh, I think less.
Okay,
This is
so-
very narrow.
Yeah. That's my understanding from reading the transcript.
I'll
So you
confer
can
with
just,
Mr. Larson, but
so
I
you
think 10 minutes.
okay, so you can just set it on my regular Jack's docket, and I'm not going to issue an order setting it, because the order setting it is usually for the purpose of reminding everybody to follow the rules of civil procedure and file a transcript. So other than that, so go ahead and set it, both motions, the motion to strike as well as the exceptions.
Very well, Your Honor.
All right, thank you, gentlemen.
Thank you.
Thank you, Your Honor.
All right, next case is Cadu versus Fazakis, 20 CA 2767. Who's here for this is a little confusing because, quite frankly, it appeared to me that the person that filed the motion, or on behalf of whom the motion was filed, is not a party. So who's the plaintiff in this 20 CA 2767 case?
Good morning, Your Honor. Robert Hines. I'm the plaintiff for Olga Cadu in the present case.
Okay, and how about for defendant in this case?
Your Honor, Joseph Trunkett for Mr. Fazakis.
All right, and how about for the movant?
It's Judge Christopher DeCosta on behalf of Gilardi Construction.
Okay.
And Judge,
So-
hi, Henry Johnson here. I'm on behalf, I was noticed for this hearing as well.
Okay.
And we represent Sanchez Enterprise Group LLC, who is a defendant in the case that's presently assigned to Judge Brody. That's the subject matter of the consolidation for this morning.
Right. Well, first of all, I don't particularly have a problem with consolidating or transferring one case or another. I think, hold on just a second. I think if I recall correctly, I have the lower case number, so it'll be consolidated or transferred to me. But my biggest problem is that this motion is not filed on behalf of a party in this case, 20 CA 2767. So, I mean, if the parties in this case are in agreement with it, I am fine with it, but that's the problem.
Judge, if I may, just a little bit of background. I had actually, and I represent Gilardi Construction in the related case, I had actually initially filed a motion to consolidate with Judge Brody. We had a hearing and she told me probably should be consolidated, but I can't do it. You have to move before Judge Krier. So I'm
Okay.
here.
Well,
I'm not sure what else to do.
how about this? Well, first of all, let me find out what's the position of the plaintiff and defendant in this case. Mr. Hines?
Yes, we actually don't object to the cases being consolidated. There was an argument put forward in the other case that there could be some inconsistency between the verdicts. And I agree. I think it would make sense to try to avoid that. So I don't have an issue with it. I'm not sure which rule of civil procedure the movement proceeded under, but of course they could move to intervene in the case. So I think it's potentially proper to allow it. And again, we don't have any objection to it.
All right, Mr. Trunkett.
Well, my client doesn't agree to it. They could get the information they need by subpoena if they wanted to, but we'll leave it at that. Let your honor make a decision on it.
All right, Mr. Johnson, anything you want to tell me?
We endorse the consolidation. The only issue we would raise is a procedural one. If it's consolidated, I think we would be operating under two different case management plans, and one plan is a non-jury trial, the other plan is a jury trial. So we'll probably, if Your Honor is inclined to grant the consolidation, we'll probably have to revisit with the court
We'll have to have a new case management plan. Okay, yeah. Well, again, it's not, this is not procedurally correct, but just so I'm not sending you guys back and forth between judges. What I'll do, what's the other case number? Oh, here it is. 20 CA 2934 is the other case number.
Yes.
Okay, so what I'm going to do is enter an order in 20 CA 2934, because I'm a circuit judge, even though it's assigned to Judge Brody, that consolidates that case with my case, which is 20 CA 2767, and transfers it to my assignment. Then I'm also going to set you all for a new case management conference, which I'll have my case managers set for you. Just make a note. Probably, we're in June. Probably I'll set the case management conference. I don't remember whether I have a case management conference date in July or not. If I do, I'll set you in July. If I don't, I'll set you in August. And I am going to be continuing to conduct my own case managements even after we open up. And I am going to be doing all of those on Zoom. So pre-trials, case management conferences, status conferences, all that kind of stuff, all can be done on Zoom. You don't have to come to the courthouse for it and spend your client's money. And I know you guys don't want to come anyway, so. All right, so anything else I can help you with?
No, thank you.
All right, so your motion's granted, but I'm granting it in the 20 CA 2934, Mr. DaCosta. So I'll need an order from you. You might as well just give it to me in both of the cases, and then I'll sign both of them. Just send it to my office email address in Word format, all right?
Judge.
All right, thank you, gentlemen.
Thank you.
Mm-hmm.
Thank you, Your Honor.
All right, next is Back versus Back, 20 CA 2953. Who's here for the plaintiff?
Ed Larson on behalf of the plaintiff, Your Honor.
All right, who's here for defendant?
Morning, Scott Welikoff on behalf of the defendant.
All right, so this is a motion to strike and to dismiss, I believe. It's defendant's motion, so go ahead.
Sure. Plaintiff has filed a complaint for seeking declaratory relief and breach of fiduciary duties. It suffers from significant flaws, some of which are admitted to in the response. One most significantly with respect to this case is the execution of the deed, which is really the subject of this lawsuit. Plaintiff alleges that it was signed in the end of March. It was actually signed at the end of February, and it becomes a pretty dispositive issue as you move down the issues of the case. So that's the first problem. Secondly, the declaratory.
But isn't this more appropriate for a motion for summary judgment? I mean, that's kind of what I kept thinking.
Well, I mean, it creates a whole problem with respect to the rest of the case. So if you have a pleading that includes something that's quite obviously false and admittedly so. Like I said in the response, he admits that it's not true of when it was signed. There was also documentation provided about when it was transmitted from plaintiff's attorney to the defendant. It becomes an issue that I believe is subject to being stricken at this point. If not, I guess plaintiff can decide on his own whether to remove that allegation, but it messes with the rest of the allegations contained in the complaint.
Well, but why do you care whether what they're saying is true? It just makes your job easier in the end.
because it leads to when the duress occurs, it leads to or the alleged duress occurred. It leads to when the defendant became the trustee of the estate, when the instructions to create the deed became at issue. So it ultimately feeds into a whole bunch of other things that I think makes it next to impossible for them to make the allegations that are included in this complaint.
Okay. Is that the only problem? Because your motion was a little bit more detailed than that.
Yeah. Oh, well, there are other issues. I mean, with respect to the declaratory relief, there's a jurisdictional issue here too. The complaint is about title to property. Plaintiff attempts to argue in their response that it's not about the title of the property, but the issues that it seeks declaratory relief about include whether or not the defendant is a beneficiary under the trust. But that's not an issue. That's not a question at issue. That's not in dispute. So you don't have a dispute in which to declare upon. The only dispute that you have that seeks to be declared upon, and one of the reliefs sought in the complaint, is to quiet title to a property in Massachusetts. As a result, because it's in rem, this court doesn't have jurisdiction. So it can't order the declaratory relief sought in the complaint.
Mm-hmm.
The other issue is the breach of fiduciary duties. It's based on the issue of self-dealing. The problem with self-dealing here is the person who did the dealing is the plaintiff herself. She was the one who signed the deed, transferring the property to the defendant. So the defendant didn't do any dealing. The only dealing he did was the preparation of the actual deed, which was prepared at plaintiff's counsel's direction. Plaintiff's counsel.
Again, though, we're getting into summary judgment type issues.
That's with respect to the facts associated with that, I understand. But again, he didn't get involved in the self-dealing. It's admitted in the complaint that the transfer of the property was done by plaintiff herself. The defendant didn't transfer the property. But again, this goes to title over the property, which becomes a jurisdictional issue once again.
Mm-hmm. Okay, so Mr. Larson?
Okay, most of that is incorrect. I mean, the bottom line is that basically defense counsel made a motion to strike the complaint as a sham. Now, I cited to the case of Reyes versus Roosh, which is dispositive on this point. Now, number one, in regard to the motion is procedurally defective. The motion was not verified as required by the rule. Second, it didn't set it for an evidentiary hearing. Third, as the court knows, the court has to decide it within.
Oh, this is a motion to strike and a motion to dismiss.
Right.
So,
and then basically the court has to decide it within the four corners of the complaint. But defendant's counsel added documents to the motion. Now, in regard to the motion to dismiss, because the motion to strike as a sham is completely defective and ill-conceived. Now, in regard to the motion to dismiss, I laid out very clearly in my response the allegations which satisfy each element of the cause of actions for declaratory judgment as well as undue enrichment. In fact, the Declaratory Judgment Act actually has a provision, which is Florida Statute 86.041, which allows a trustee or a beneficiary or another interested party in a trust or an estate to bring an action for a declaratory judgment. Now, in this particular case, we have a disinherited son who is a lawyer in 3 states who exercised undue influence over a woman immediately after her father's death in order to walk away with a piece of property in Massachusetts. So the question is not basically what the title is in the Massachusetts property, because that remains in the trust. There's no issue as to the chain of custody or the chain of title. The issue is,
why are you asking me to quiet the title then?
No, I'm actually, it's paragraph 66 and 67. The declaratory judgment actually specifically asked this court to declare that the defendant is not a beneficiary of the trust and is not entitled to any trust act.
I'm looking at your wherefore clause, subparagraph C, and it says declaration quieting title to the Wealth Fleet property in the GCB 1994 trust.
Yes, but correct, Your Honor. But the declaratory action request inside the pleadings forget the wherefore clause, actually states whether or not he is a beneficiary of the trust and entitled to a trust action. Now, correct. I mean, basically, the quiet title action is, not appropriate because the trust remains the owner of the property, and basically, there is no problem with the chain of title because it went from the owner or the grantor to the trust and remains in the trust. So that could be basically a denial of the relief, but based upon the allegations for declaratory judgment and unjust enrichment, they're properly pleaded, and these documents attached are extraneous and can't be decided, or the truth of the allegations can't be decided on a motion to dismiss, per the Supreme Court in Goodmakers versus Goodmakers. So
I'm aware.
there might be some errors in a complaint, but at this point, it should not be dismissed. We could perhaps amend it down the road when we get to discovery, but at this point, we're not looking to for anything other than to declare that the defendant is not a beneficiary of the trust and is not entitled to an asset of the trust.
Mr. Wickenden, do you have anything you want to tell me?
No, Your Honor. I'm merely observing. I just filed a motion to intervene. I represent the other beneficiary of the trust, and I'm just here to protect her interests.
All right, Mr. Welikoff, go ahead.
Yes, Your Honor. A couple things. Plaintiff's counsel states that the property remains with the trust. That's not true. There was a deed admittedly signed by plaintiff, witnessed and transferred to and delivered to the defendant. Its recording is not the evidence of whether or not there was a transfer. So saying that the property remains trust property is not entirely accurate. And again, the entire complaint is about trying to return this property back to the trust, trying to quiet title with respect to the trust, because he's admitting there's an interest there, which the court can't ultimately decide. There is no dispute about whether or not the defendant is a named beneficiary in the trust. It's not in dispute. It's not even alleged it's in dispute. So the other reliefs requested in the declaratory count don't actually, it's not subject to declaratory relief because there is no current dispute. The only dispute is about title to the property. And again, with respect to the breach of fiduciary duty, plaintiff's counsel keeps talking about unjust enrichment, which isn't a cause of action alleged here. It's breach of fiduciary duties based on self-dealing. But once again, the dealing was done by plaintiff, not by the defendant. The person who transferred the property and signed the deed was plaintiff, not the defendant.
Well, I'm going to grant your motion to strike only as to the claim in the wherefore clause that requests that the court quiet title. Other than that, I'm denying your motion to strike. I am, however, granting your motion to dismiss to allow plaintiff to clean anything up that it needs to clean up, especially considering that I've stricken that one request in the wherefore clause. And however, I think you're getting ahead of yourself, Mr. Welikoff. I mean, a lot of what you're telling me is just more appropriate for a motion for summary judgment. So let's see where we are I'll give you 20 days to amend, Mr. Larson. We'll see where we are then.
All right, so we're striking the wherefore clause as to the quiet title.
Yep.
And then it's dismissed.
With leave to amend.
Leave to amend.
Because I'm striking part of it, so you can take a look at it. And if you want to change anything else, have at it. But I'm not dismissing on that basis. I'm not dismissing on the basis that Mr. Welikoff says that there's inaccuracies in there. That's not appropriate. If you've made inaccuracies, well, that's your problem.
All right, so but then is it more appropriate to say that basically the motion to dismiss is granted as to the subject matter jurisdiction issue because we put in a wherefore clause that we seek the quiet title rather than a motion to strike?
That's fine.
Okay. All right.
I'm sorry. So I'm sorry to extend this any longer than it needs to. I just want to make sure that there's no dispute between plaintiff and I regarding what the wording should be.
Well, I would prepare the order stating that the motion to dismiss is granted
I'm granting the motion to strike in part, and I'm granting the motion to dismiss in part with regard to the quiet title action. I'm giving you 20 days to amend, Mr. Larson, and that can include any other amendments that you want to make also.
Understood.
All right.
Okay,
strike
thank
the
you, Your
part
Honor.
and dismiss
All right.
As to the quiet title action. Right.
Yep. All right, guys. Thank you.
Okay.
Thank you, Your Honor.
Yep.
Have a good day.
Thank you.
Thank you.
And then I have one more case, but it doesn't appear that anybody's here, Kat. The SFR Services versus Family Security. Did they cancel?
Yeah, because that's all I have for today.
For today? That's all you have?
Well, we have 11 o'clock.
I was going to say, I thought we had on 11 o'clock.
Yeah,
Okay.
we have 11 o'clock. But
Okay.
8:30 is done.
Okay.
Okay.
They must have figured that out since last night. All right. Well, thank you. And I'll talk to you at 11.
Okay.